Title 12 of the Revised Corporation Code establishes the close corporation, a hybrid legal structure combining the limited liability of a standard corporation with the operational intimacy of a partnership. To legally qualify for this status under Section 95, an entity must strictly adhere to a hard cap of no more than 20 stockholders and maintain an absolute prohibition on listing its shares in any public stock exchange. Looking at Section 95, we see three mandatory conditions, specifying the 20-person maximum, explicitly restricting share transfers, and completely banning public offerings. Furthermore, the law absolutely bars mining companies, banks, public utilities, and educational institutions from organizing as close corporations due to public trust. But this status is also highly fragile. Under the rule established in the San Juan structural case, a close corporation instantly loses its classification if at least 2/3 of its voting stock is acquired or controlled by another corporation that is not itself a close corporation. A common legal error is assuming that because the structure operates like a partnership, the stockholders are personally liable for all corporate debts. The doctrine of separate juridical personality remains fully active here, protecting personal assets from standard corporate creditors. The closed corporation functions as a closed legal ecosystem. Its advantages exist only as long as it maintains strict compliance with the 20-person limit and absolute isolation from public markets. Section 96 introduces a distinct operational advantage, the legal authority to bypass a traditional board of directors entirely and allow stockholders to manage the business directly. This diagram maps three flexibilities: classification of directors, greater quorum, and management directly by stockholders. Stock classes can elect designated directors, ensuring minority representation. But direct control brings risk. Managing stockholders lose the corporate veil, assuming exact fiduciary duties and legal liabilities of formal directors. Section 96 dictates a very strict trade-off. It offers the speed and convenience of direct ownership control, but demands the assumption of high-stakes personal liability for any mismanagement. To maintain the strict 20-person limit, a close corporation must restrict how shares are sold. However, Section 97 prohibits an absolute ban on share transfers. Instead, restrictions must take the form of an option to purchase, a right of first refusal granting existing stockholders or the corporation the chance to buy the shares first. Section 97 establishes the triple document rule. Transfer restrictions must be recorded in three places: the Articles of Incorporation, the Bylaws, and the Certificate of Stock. If omitted from any document, an innocent buyer in good faith acquires the shares free of the option. Section 98 creates a rigorous defense mechanism. When the qualifying conditions and transfer restrictions are conspicuously printed directly on the certificate, the law applies a conclusive presumption of notice. The buyer is legally deemed to know the restrictions, destroying any claim of being an innocent purchaser. Armed with this presumption, the corporation holds the absolute right to refuse to register the transfer, rendering the unauthorized sale effectively void. There is exactly one statutory cure for a violative transfer. The breach can be validated only if it receives the explicit, unanimous consent of every single existing stockholder. Share ownership in a closed corporation operates as a contractually locked position. Liquidity is intentionally restricted, and any deviation from transfer protocols requires total consensus to execute. Section 99 addresses how internal agreements are governed. It validates written agreements that dictate voting rights or restrict the board's discretion, stating they cannot be invalidated simply because they make stockholders operate like partners. This partnership-style operation triggers a specific legal hazard. Managing stockholders become personally answerable for corporate torts unless the entity maintains adequate liability insurance. Moving down to Section 100, the code relaxes standard corporate meeting formalities. Actions taken without a meeting are legally valid under 4 parameters: written consent, absentee ratification, customary informal action, or knowledge without prompt written objection. That final condition places a strict burden on passive dissenters. If an absent director disagrees with an informal corporate action, verbal complaints are legally useless. They are deemed to have ratified the act unless they file a prompt, formal written objection with the corporate secretary. Title 12 codifies informal business practices. It ensures off-the-record decisions are legally binding, while placing the burden on formal dissent squarely on anyone who objects. This visualization illustrates the absolute nature of preemptive rights under Section 101. Unlike a standard stock corporation, a close corporation's stockholders' right to scale up proportionally extends to all stock issues, including the reissuance of treasury shares and shares issued for property or services. This proportional lockdown is the default legal state. It applies automatically and forcefully unless the articles of incorporation contain explicit language denying the right. Modifying this internal structure requires significant consensus. Section 102 states that any amendment attempting to delete the close corporation qualifying provisions or reduce voting requirements requires an affirmative vote of at least 2/3 of the outstanding capital stock. Looking closely at the dossier for Section 102, we see a critical mathematical requirement. The 2/3 threshold explicitly includes all shares, whether with or without voting rights. Preferred non-voting shares must be counted in this calculation. The statutory framework actively defends the original proportional control of the owners. It mathematically protects minority stockholders from stealth dilution or unilateral charter changes by majority factions. Because close corporations require high degrees of consensus, they are highly susceptible to deadlock. This occurs when directors or stockholders are so severely divided that required votes cannot be obtained, completely paralyzing business operations. To break this paralysis, Section 103 grants the Securities and Exchange Commission extraordinary equitable powers. Upon written petition, the SEC can intervene directly, arbitrating the dispute or inserting a permissional director to act as an impartial tiebreaker. The statute imposes a strict impartiality requirement on this appointee. The provisional director cannot be a current stockholder or a creditor of the corporation, ensuring their decisions are completely independent of the internal conflict. The SEC's authority here overrides standard corporate rules. In resolving the deadlock, the Commission can order the corporation to purchase a dissenting stockholder's shares, regardless of the availability of unrestricted retained earnings in its books, a direct exception to the standard trust fund doctrine. When the intimate management structure fails, the law prioritizes operational survival. The SEC is empowered to bypass traditional corporate technicalities to restore function or force a clean separation for the advantage of the stockholders generally. Section 104 provides a final failsafe for trapped owners, the absolute right of withdrawal. Any stockholder in a close corporation can compel the entity to purchase their shares at fair value for any reason. Here in the text of Section 104, we see the single limitation on this exit right. The corporation can only be forced to execute this buyout if it has sufficient assets in its books to cover its existing debts and liabilities, protecting third-party creditors from sudden capital depletion. If the situation is beyond repair, a stockholder can petition the SEC to compel the total dissolution of the corporation. This option is available when those in control commit acts that are illegal, fraudulent, oppressive, or involve the blatant wasting of corporate assets. Title 12 demands a dual mindset from practitioners. While the boundaries and defenses of a close corporation remain strictly corporate, its internal liabilities, operations, and vulnerabilities are inherently those of a partnership.